A court claim arrives, the paperwork lands, and suddenly the word defense appears in big legal letters. Not defense like a football back four, not defense like a superhero shield. In civil litigation, a defense is usually the defendant's written response to the claim. It generally explains which parts of the claim are admitted, which parts are denied, and which parts are not admitted because more information is needed. In plain English, it is the document that says, "Here is the other side of the story." In England and Wales, civil claims are usually shaped by the civil procedure rules. CPR Part 15 deals with defense and reply, while CPR Part 16 deals with statements of case. A defense is one of those statements of case. A statement of case is basically the legal paperwork that sets out each side's position. The claim form and particulars of claim set out the claimant's case. The defense sets out the defendant's response. Together, these documents help the court understand what the dispute is really about. The deadline for filing a defense depends on the court papers, the date of service, and whether an acknowledgement of service is filed. In many Part 7 claims, the defense deadline is commonly 14 days after service of the particulars of claim, or 28 days if an acknowledgement of service is filed, but the exact deadline should be checked carefully. A defense is generally linked to the points being made in the claim. Court paperwork can sometimes feel like someone emptied a filing cabinet into a blender, but the basic idea is fairly simple. Claim point, response point. For example, where a claim says money is owed under a contract, the defense might deal with whether there was a contract, what the contract terms were, whether the work or goods were provided, whether the amount claimed is accepted, and whether any payment or set-off is relevant. In many cases, the structure of a defense follows the structure of the particulars of claim. This keeps the dispute tidy, or at least tidier than the average kitchen drawer. A defense typically uses three main types of response. First, an admission. That means a fact is accepted. For example, a date, a name, or the fact that there was some form of agreement. Second, a denial. That means a fact is disputed. A denial is often accompanied by the reason why the point is disputed, because a bare "nope" is not usually very helpful in court paperwork. Third, a non-admission. That usually means the defendant is not able to admit or deny the point, often because the claimant has not given enough detail or the information sits outside the defendant's knowledge. A defense is not usually the place for every single document, message, receipt, screenshot, and dramatic side story. Evidence normally comes later. The defense is usually about the pleaded case, the main facts, the disputed issues, and the legal basis of the response. That said, the defense often refers to important facts that explain the dispute. Dates, payments, conversations, invoices, terms, defects, delays, cancellations, and previous correspondence may all be relevant, depending on the case. A common defense problem is vagueness. Phrases like, "the claim is wrong," or "the claimant is lying," do not usually explain much on their own. Clearer defense documents often identify the specific allegation and the response to it. Another common issue is arguing with everything, even the obvious parts. If a defense denies every single point, including basic facts that are plainly correct, the real dispute can become harder to see. Litigation loves clarity. It may not send flowers, but it does appreciate a clear paragraph. An unclear defense can create difficulties in the case. If the defense is unclear, the court and the claimant may struggle to identify what is actually disputed. That can lead to confusion about the issues, extra correspondence, extra hearings, or applications about the defense itself. In some situations, a defense that does not properly answer the claim may leave important allegations unanswered. In civil litigation, unanswered points can create difficulties because the court process depends heavily on what is admitted, what is denied, and what remains in dispute. A defense that is unclear or incomplete may affect how the case is managed. The court may need to give directions to clarify the issues, or a party may apply to strike out parts of the defense where it discloses no proper answer to the claim. That can turn one dispute into a dispute about the paperwork. Legal admin, the plot twist nobody asked for. There can also be costs consequences. In many civil cases, the way a party conducts litigation can affect costs. Even in small claims, where costs are more limited, court fees, hearing fees, and some expenses may still matter. A defense that causes unnecessary confusion can become part of the wider picture of how the case has been handled. A defense can also include a counterclaim in some situations. A counterclaim is usually a claim brought by the defendant against the claimant in the same proceedings. For example, where the claimant says money is owed and the defendant says the claimant actually caused loss. That becomes more than a simple response. It becomes a claim going the other way as well. There is also the statement of truth. In civil litigation, statements of case are normally verified by a statement of truth. This is the formal confirmation that the facts stated are believed to be true. It gives the document legal seriousness. Not serious like a judge's wig in a thunderstorm, but still serious. Dishonesty in a defense is treated very differently from ordinary disagreement. Civil litigation often involves two sides seeing the same events differently. That is normal. But a defense verified by a statement of truth is not just casual paperwork. The statement of truth confirms belief in the truth of the facts stated. The civil procedure rules also refer to contempt of court consequences where a person makes, or causes to be made, a false statement in a document verified by a statement of truth without an honest belief in its truth. A false statement verified by a statement of truth can have serious consequences, including possible contempt proceedings in appropriate cases. It may also damage credibility, affect costs, and affect the court's view of the evidence. In litigation, honesty is not window dressing. It is part of the structure holding the whole process together. Here is a simple example. Adam, a sole trader electrician, is sued by Bob, his client, for the return of money paid for electrical work. Bob says the work was not completed. Adam's defense might admit that there was an agreement and that Bob paid a deposit. It might deny that the work was abandoned. It might say that access was not provided on certain dates, that materials had already been purchased, and that part of the work had been completed. The defense would usually focus on those key points, rather than turning into a full autobiography of Adam's van, tools, and tea breaks. Once a defense is filed, the case usually moves into the next stage. The court may send directions questionnaires, consider allocation to a track, or give further directions. In small claims, the process is generally more informal than higher-value litigation, but the defense still helps define the dispute. In many cases, plain sentences are used to explain the issues clearly. The overall idea is simple. A defense generally tells the court what is accepted, what is disputed, why matters are disputed, and what facts are relied on in response. So, when the word defense appears, it is not just a formality. It is the defendant's written position in the case. It helps turn a pile of allegations into a set of issues the court can actually understand. And in litigation, that is often the first big step, turning legal fog into something that looks more like a map.